Hello, my name is Lee Presser. This is my show. I speak frequently to very interesting people. Some of these conversations are so exciting, so intellectually stimulating, I thought others might like to listen in. This is the reason we started recording Conversation with Lee Presser.
Welcome to Conversation with Lee Presser. Eminent domain is a constitutional power granted to the government to buy property even if the property owner objects. In 2005, the U.S. Supreme Court decided Kelo versus City of New London, Connecticut. Although the decision was controversial, it was not the first time public use had been interpreted by the Supreme Court as public purpose. Media reports of the Kelo decision led some people to believe that local government had been granted the power to purchase anyone's property and turn it over to another private party. Opposition to the ruling was widespread. As a result of the decision, many states changed their eminent domain laws. To discuss the current state of the law is today's guest, Robert Denlow, a St. Louis attorney who specializes in property law. Robert Denlow, welcome to Conversation.
My pleasure.
Did I get that right?
My practice exclusively deals with eminent domain.
Okay. So the United States Constitution, this is the basis of your work, right?
My work is solely interpreting and applying a phrase in the Fifth Amendment.
Right.
You shall not take private property unless it's for a public use and just compensation is paid.
Right. Okay. And their just compensation is sort of I guess it's pretty well understood, although you do have some difficulties with some of what just compensation is.
Well, what's
ironic, the other part,
go ahead.
The public use versus public purpose. Now there's, and I know I just said that in the introduction, but I'm not sure that the people who were listening to that really understood what I meant by that. So why don't you explain it?
Well, let's just set the stage. In colonial times, and even before then, the government would take property as they would need it, confiscate it, and there would be no test for what purpose, whether it be legal or not, nor would there be any payment made for the property. So when you have the Fifth Amendment adopted in the United States, what you have for the first time, or one of the first times, is a restriction on the government in using what is deemed an inherent power of the sovereign state. That is, eminent domain, the forcible taking of property, is really perceived as something inherent in a government's ability to function. It doesn't need to look for a piece of paper. It's part of its life and soul.
This comes really from kings.
From kings.
Kings owned everything except what they let you have.
And so when we get to the Constitution, we add amendments to the Constitution initially, including the Fifth Amendment, and we say, wait a minute, we'll apply two restrictions on the power of the government to use forcible taking of property, which is called eminent domain. Alternatively, it's called condemnation, one and the same thing. Mm-hmm. And so the two restrictions are, when the government knocks on your door and says, we want to take your property to build a road, we have to go to court and get the judge's blessings that the use to which we are going to use this power is for a public purpose. And secondly, that we intend to pay just compensation to the property owner. Now, what's interesting is in the Constitution, there's no real definition of what a public use or public purpose is, nor is there a definition of what just compensation is. And as we go from one generation to the next, as we go from an agrarian society to an urban society, it becomes much more difficult in applying the eminent domain. Mm-hmm. And we see the limits of it, or the Star Trek version, we're going where no man has gone before. As we become more urbanized, we're trying to figure out, how do you save old cities? How do you save old suburbs unless the power of eminent domain is used to collect properties and do larger projects which are essential to make it economically work?
Now that's a post-World War II philosophy, right? After World War II, I believe the Supreme Court, and I forget the decision, they actually made a decision or several decisions about urban renewal, didn't they?
Right, the famous
changed. Go ahead.
U.S. Supreme Court Justice Douglas in the Parker decision. And the test was, cities were faced with decay, slums, And the term we use generically is blight, a blighted area. That's what you hear in today's statutes. And the cities had to decide, how do we save ourselves? And one of the answers was, we need to be able to take the property from either slum landlords or from people who were living in dilapidated areas and use it for a purpose. It could be the waterfront in St. Louis, Mill Creek. It could be where the stadiums are. It could be where Old North St. Louis is a topic right now.
I was just going to ask you, there is a fellow by the name of Paul McKee who has been buying, I mean, he owns large number of tracts in North St. Louis City, but he doesn't own all the tracts, he just owns most of the tracts, right?
He owns acres and acres and acres in North St. Louis, a large tract. So let's look at that. A lot of the area that he bought was already vacant. A lot of the structures that were still standing were dilapidated. And yet there were some good tracts in between. So let's say you have a block that is vacant, except for one really nice house.
Right.
Okay?
Okay. And that person's been there, living there for the last 50 years.
50 years, raised the family, grandchildren.
And they kept the house nice.
And they kept it nice.
So now,
and
St.
now
Louis
you
City
have,
comes to them and says,
we need to save this area of the community. We want to put a big project because in this day and age, that is the only thing that could economically work, first of all. And secondly, to save an area, you've got to take control of a large area. To build one house in the name of preservation will not work, or restoration will not work if the person who's going to occupy that new house doesn't feel the surrounding area is secure. Right? Will not. So you either bring in the city or a large developer with his money, in part, with giving him the powers to do a project knowing that the surrounding area he'll be able to protect. And so that lady with a nice house, whose grandchildren were growing up, may have to go in order to save a whole block or multiple blocks. That becomes the trade-off.
Well, what happened to the idea a man or a woman in this case is property is their castle, their house is their castle. Remember that?
I would say in agrarian times, that was especially true. As we get more urban, so that the neighbor next door, if he is making too much noise and waking up your children next door, and you knock on his door and say, can you please turn down the volume? And he says, what? This is my castle? Buzz off, guy? Is that what you think this is going to be all about? I don't think so. Those days are kind of gone to some extent where we expect reasonable regulations so that you leave me alone, I leave you alone at least. And then you could be the king of your own castle. Although if you want to build a house, a new house next to that guy, you're going to have, quote, setback lines, construction code, all imposed upon the government, even though you want to say, wait a minute, you're going to increase the cost of my building my home. But that or the trade-offs for safety, regulation, etc., and living in an urban area. When we get to eminent domain, I am the king of my castle. Where the rubber hits the mat is when we take eminent domain to the next level. So we first talked about, Lee, the idea that the government we would agree that eminent domain should be used for sure to build roads. There's a reason roads are built straight. If somebody's in the way, doesn't want to sell, the little old lady who happens to be in the way, or the little old man who happens to be in the way, and even though they have done nothing wrong, even though their house may be a $500,000 house, if they're in the way of the highway project, they will be just gone, displaced. There'll be payment made for it, and life moves on, and hopefully they will have replaced it.
Now, you're the guy that the little old lady comes to,
Yes.
right?
I represent only property owners.
Right. So you're that guy, and so now what's the process? She has already received notice from somebody or another?
Yes. Every state governs their own procedures, and every state is a jealous mistress of their eminent domain statute. It's more controlled by the states. But generally speaking, the process would be something like this. The highway, let's use the highway department, would send a letter, hey, we're coming your way, we're giving you notice. The project will be starting in a year or so. We intend to value your property. We will make you an offer, and we'll provide you relocation assistance to help move you. The lady says, I don't want to move. And if it's an undisputed public purpose, like building a road, chances are at the end of the day, her difference of opinion with the government will be probably more about what is her just compensation and what are her relocation rights, as opposed to stopping the project. Let's take it to the next level.
Now, is this a court or a panel, or who makes these kind of decisions?
Ultimately, it will be a jury if it gets that far. In the state of Missouri, in the early stages, a judge will appoint 3 people called commissioners, like arbitrators. They come out, kick the tires, they inspect your property. They may be appraisers, they may be lawyers, real estate people, maybe a housewife. And it occurs early in the process. Why? Because only when the government pays the property owner something can the government proceed to take your property. So instead of waiting for a jury trial a year and a half later, you have a quick take process in Missouri, and Illinois has the same thing, where the judge becomes sort of the commissioner and decides the early compensation. And if either side doesn't like the early compensation, you can relitigate that before a jury.
Okay.
Okay?
Now let's assume for a second that it's not a little old lady. Let's say that it's like Dave Sinclair Ford is in the way. And we're talking about millions and millions of dollars worth of business that occurs on that piece of property every single year. Are we just going to talk about the value of that plot of land? Or are we talking about the millions and millions of dollars worth of business which would have occurred over the next 10, 20 years that won't occur there?
Great question. Now we're shifting from the idea of under what circumstances should the government have the right to take, where, before I get to Dave Sinclair, I just want to make sure we have the big picture here. We started with the government taking property for a road, undisputed.
And we're still looking at
undisputed.
A road. Right.
And then the next level, we're going to talk about, okay, they take it for blight purposes. And final level, they take it for economic redevelopment, which is really the cutting edge controversy that riled the country in 2005 or so.
Right.
And then we flip the coin, and now we're talking about just compensation, where you have Dave Sinclair, and Dave Sinclair gets a letter, or an auto, let's say an auto dealer, gets a letter saying the road is coming your way. From the government's point of view, they look at it in terms of bricks and land. What they are basically saying, well, we'll pay you money, just go move your operation down the street.
But everybody knows I'm here, sir. They come to this spot, they don't go down the street.
Or there is no place down the street.
Yeah.
Or legally I can't do it. For example, let's say a McDonald's is in the way. And because of the franchise restrictions, I can't go down the street because I would interfere with another McDonald's territory. So I am out of business. Or Dave Sinclair says, what you will pay me, here's another flip. Okay, right. Dave Sinclair says, I am at the intersection of 270 and 55. There's only 4 corners. There's nowhere else to go. All the corners are filled. If I move, I will lose business no matter what. Or if I move, I will go out of business. if I'm a McDonald's, because I can't move anywhere within that territory.
Well, so can they make this argument during the court, or are we talking bricks and mortar?
A lot of, a third of the states let you talk in terms of business losses. Missouri does not, as a general rule. Illinois does not as a general rule. There are exceptions, which brings me to the big point. And the big point is this. Who says just compensation is limited to bricks and land? Does the Constitution? No.
No.
Not defined in the Constitution. So who says it's limited to bricks and land? And let me throw this out to you,
I guess a
lady.
legislature, there must be a rule or a law.
Well, I'll tell you in a second. At the same time, the idea in law, when somebody is hurt, is to indemnify them for their losses, to make them whole. If I'm in a personal injury case where my property is damaged, but in this case it's a car, I lose 3 days of work, I get paid for my economic losses, my business losses, and they also throw in something called pain and suffering or whatever else they have. Person's paralyzed, maybe medical care, whatever. And yet, when it comes to condemnation, all these categories fall to the wayside. It's just talking about property to begin with. In my readings, it seems that when the railroads were building across the United States, they were having problems in a lot of local jurisdictions. And they were successful in having the courts interpret just compensation in terms of bricks and land as a general rule, in terms of just property. And that kind of stuck on the legal wall, so that the judges and the legal decisions were the ones that restricted the definition of just compensation to bricks and land. When you get to about 1970 and you have the Eisenhower's interstate highway system, when Eisenhower did the interstate highway system, it kicked eminent domain to new levels we never saw before. Think about it. We are going to create an interstate highway system across the whole United States.
Through developed areas.
Through developed areas, through farms, and these roads are going to be wide, they're going to be safe, and they're going to be straight as an arrow. And so condemnation went through the roof in terms of activity. And there was a cry from a lot of people that said, wait a minute, you're going to pay me for my bricks and my home? Something called fair market value, which is just a fancy way of saying if you put a for sale sign on your house, what would you get for it on an open market? And that's what we'll give you. But you say, wait a minute, my business, I have to replace it, and I can't replace it if I just put a for sale sign out. There's nothing for sale that's like my business. I have to build a new one, or I have to really jerry-rig something. I had a $10,000 square foot business. The only thing close to it is a 20,000 square foot business. You expect me to take more money out of my pocket to pay for a bigger building when I don't even need it, but it's the only thing close to me? You want me to go out and refinance and get a bigger mortgage? I can't even afford the mortgage I have on my 10,000 square foot building.
Well, I guess the answer is yes.
So the federal government steps in for one of the first times, and they say, oh, we'll create something called relocation rights.
Oh.
We'll help you move, we'll pay for your moving. Up until then, we'll pay you for your bricks and your land, and oh, by the way, from that, you got to take money out to move. And the feds heard the cry, and they said, time out. We will step in. Not only will you get money for your bricks and your land, we'll pay to help you move. Under some circumstances, we'll help a little bit with your business interruption. And that helped a little. It was like putting a little patch on a tire that needed to be replaced. That was that kind of cure. But it was a start in the right direction. And then there's about a dozen states or so that provide for business damages to help Dave Sinclair. And then the judges and the legal decisions have stepped in to make various exceptions under certain circumstances to help with the economic losses that a property owner would suffer.
So now, does case law cause this evolution?
Yes.
So
And it's a mixture of case law with state legislatures stepping in. The good example where state legislature stepped in is where we got what I call to the cutting edge, which is this. A community, a city in Connecticut needs to rebuild itself. They have a big employer called Pfizer Pharmaceutical. Pfizer says, we want to stay in your town, but we need to grow. We have all these jobs. We don't want to leave town, but we will. But we need to grow. And the community says, okay, we want to keep economically sound. Here are some properties right next door. So the city could be economically strong by getting taxes from Pfizer.
More
They say to Pfizer, we'll condemn so you, a private company, can stay in town and grow and keep our community alive and keep the jobs here. Now, have we gone over the edge of what a public purpose is? Can you take property just for economic growth of a private company?
Well, this is where you're describing Kelo, the Kelo decision.
This is the Kelo decision.
The Supreme Court at that time, anyways, I don't know about today's Supreme Court, but at that time the Supreme Court said, yes.
Yes, that an economic purpose is legit. Now,
and yet, wait,
Go ahead.
and yet, in Michigan, in Detroit, in the Poletown decision, that similar sort of thing was decided for the benefit of GM, but then, and I'm forgetting the case name, in
Poletown.
2004.
they reversed.
I mean, the Supreme Court of Michigan completely, I mean, they went all the way back and said, all of our decisions were wrong. We're going, you know, when we made this decision way back here, we took the right fork, we should have taken the left fork, and then they just went all the way back and said, from now on, it's the left fork for us.
Right, and what is most interesting from the Kelo decision, which is the one that went to the U.S. Supreme Court, isn't the decision itself, because ironically, Pfizer never did expand.
Oh.
That's the irony of the whole thing.
They took the land?
You know, I'm not even sure they ended up taking the land or not. The decision was made, it got embroiled in politics, they never did expand. I don't know if they even took the property or not. They may have taken it, but the project never went through. But the point is this. Here's the competing issues. You have a city that's trying to preserve jobs and grow economically. And from a financial point of view, from jobs created, from the tax base preserved or expanded, if you follow the money, it makes sense. When you come over to the other side of the coin and you say, wait a minute, what is private property if it isn't the ability to use it, to control it, to own it? And if you believe in a country like America where the protection of private property is a cornerstone of our freedoms, you know, it sounds generic, but that really is true.
Well, it's what defines the United States versus a lot of other countries.
Versus socialism, communism. We always come back to the right to use and enjoy and dispose of private property when you choose to dispose of it, whether it be a car, a house, your business, your kids' clothes, whatever it is, that is an inherent cornerstone of America's freedom and success. So now you have the competing things, because what you're telling this homeowner, we are going to take your home and give your property to a company that is going to create jobs, give an economic base, and preserve this community. And this is where we get to the problem. Now, here's one of the great secrets of the use of eminent domain. The truth is, we've been doing taking of property for economic purposes for a long time.
Oh, yeah.
but we disguise it under the word of blight. And what we do is, when we blight a rundown area, nobody has a problem with it, okay? You know,
it
it's
just
run
depends on
down,
when you define
whatever.
something that's not bad.
But what we have done over
Yes.
time is we have stretched out the definition of blight to almost fit anything you want. If it makes sense to the city in partnership with a developer, we have often stretched the definition of blight so that it's really, truthfully, for economic purposes, but legally it's under the guise of blight.
We got about 2-3 minutes left here. Is there anything we haven't covered that you want to cover in the next couple of minutes?
No, except that what I anticipate happening is that a lot of states have passed legislation to restrict the use of eminent domain. And I think the pendulum has gone so far over to that side of restriction that what's going to happen is that those cities that have an arm tied behind their back to try to save itself will eventually see the pendulum coming back more in the center, so that for economic purposes, under some circumstances, it's going to be more sanctioned. At the same time,
you and I talked about I mean, it used to be there was like thousands of acres of free land available. A guy might own thousands, but now it's been broken down to little lots that are 50 by 100 or 200 by 300. You're talking about being able to recollect all these little lots to be able to have bigger projects.
North St. Louis, Cortex, which is that area between St. Louis U and Washington U Medical School. They're trying to put a tech center there. They're trying to take out all the warehouses and things like that and save it. Without eminent domain to save cities and older cities, what you're going to see is sprawl. If a company wants to come in, they say, do I want to locate in the city of St. Louis? Is there land available for me? Or am I better off buying a farm out in Wentzville and put my plant out there?
And that
is an issue for companies.
And so urban sprawl equals more roads, more travel, people having to drive from well, in some cases, they're living out in West County and driving all the way downtown.
Right.
Now you're talking about coming from maybe the Central West End and driving all the way.
A guy like Paul McGee is taking large tracts of land, saying, wait, there's an alternative to going out to Lincoln County in Missouri or somewhere far out in Illinois. I have 10 acres, 20 acres here. We can make it work, and you could still be part of the local community in St. Louis, for example.
Boy, I'll tell you, these are, and we're about done here, but I wish we had more time. Going to have you back, and we'll talk further about this. But these are really striking, very, very striking issues about that woman that has been living in her house for 50 years and deciding to take it away from her.
Right.
Thank you very much for being with us today. Certainly
My pleasure.
Appreciate it. And to my audience, I've been speaking with Robert Denlow, a St. Louis attorney who specializes in property. If you have any problems, give him a call. Thank you. See you next time. Oh, and this is on YouTube, so show it to your friends. Goodbye.